Let's talk about custody in California law. A lot of parents who are unaware of the process in California, when they contact me, first thing they say, I want 50-50 custody, or I want sole custody. And I don't want the other parents to see our children because I'm super pissed. He or she cheated. So let's talk about what custody means and how to get 50% and how to lose custody. Custody is a legal term that explains what both parents' rights are regarding where the child is living, which is physical custody. If we say joint physical custody, that inherently is presumed that the child is going to be living with both parents equally. If we say sole custody to, let's say, mother, then it does not mean that the child is not going to see the other parent. It just means that the child primarily is living with mother for the purposes of having one address when applying to schools, but can also see another parent 40% of the time. Then we have custody on the legal. Legal custody and physical custody are two different terms. Legal custody means who makes the decisions for the child. If we say joint legal custody, then both parents make decisions, meaning one parent cannot decide which school to go and let the other parent know. No, the parent who would like to go and apply for a specific school would need to get consent, written consent from the other parent in order to even apply. That's joint legal custody. When parents are living together, they're just making decisions together. I'm talking about when one parent files for divorce. There is no established ground rule what the custody is yet. We operate that it's in the best interest of the child to have both parents decide together until the court says something otherwise. When someone files for divorce, there is so-called automatic restraining order, which means the parent who files or the parent who receives the filed paperwork is not allowed to unilaterally move the child out of state. It would be violation, sanctionable violation. It could potentially result in losing custody. So once we establish the ground rule that custody is something that we establish in the divorce process, then the next question is how to get joint custody and how not to lose joint legal physical custody. First of all, if you are the parent who is concerned that the other parent might not give you joint custody, or you would like to get sole custody, then first thing you need to do is to file a request for order. It's FL 300, and explain why you think joint custody is in the best interest of your child, or why do you think sole custody is in the best interest of your child. And let's walk through examples. If both parents work, both parents are good parents, they just don't get along, even if someone cheated, doesn't matter, the court will grant joint legal custody. And the court will look at what is your current schedule, work schedule, living environment. Would it be good for a child to, depending on the age of the child, to go back and forth on a frequent basis or week on, week off basis? Typically, the younger the child, the more frequent the contact is going to be beneficial for the child. So, for example, if the child is a 3-year-old child and both parents are working, then the court will say probably 2, 2, 3. 2 days with mom, 2 days with dad, 3 days with mom, which is the weekend, and then alternate. Then if the weekend was with mom, then the next 2 days was dad, mom, and then again the dad gets the weekend. So that's called 2, 2, 3. When the children are older, perhaps the attachment style is different, and parents could agree. Usually it's not provided or something ordered by the court. I never seen the court order week on, week off, unless both parents are willing to do this kind of schedule. For older children, week on, week off is more convenient because then you don't have these frequent exchanges. If parents don't like each other so much so that they cannot do exchanges at a neutral location, they usually pick school as a location. So one parent is dropping off, the other parent is picking up. And then if school is not in session, then the parent who is picking up drives to the other parent's home, and the parent who is picking up after the visitation finished drives to the other parent's home. If the parents are living far apart, the court orders them to meet somewhere in the middle. How to lose custody? I have so many examples. Well, the first classical example is domestic violence restraining order. If one parent is exhibiting abusive behavior towards the other parent and the child is present, witnessing the abusive parent behavior, and that parent who is victimized by that behavior files for domestic violence restraining order, and the court grants it on a temporary basis within 24 hours upon filing, then the restraining order, which is the DV110, it's actually the order, will say protected parties, children, child, the parent, and what the visitation schedule would be, which is DV140. And then the other parent would have to follow that visitation schedule pending next hearing. At the next hearing, depending on what the allegations are, the parent can decide to get a free continuance or move the case forward with a trial or litigate right then and there. There is a presumption. If that parent wins and the court finds that the parent who was abusive, then the court can make a presumption. It's called a 3044 presumption. It's Family Code section 3044 that says the parent who got the restraining order will be presumed to be the parent who has sole legal and physical custody. And in order to rebut the presumption, meaning if the other parent wants joint legal custody, then the other parent must go through different programs ordered by the court in order to get joint legal custody and need to file another motion to rebut that. If this is a legitimate case, of course, that's the way to get sole custody. Now, the cases get gray when one parent is using domestic violence as a leverage. Unfortunately, I have seen it so many times where attorneys convince the client that the client is victimized when the client is like, nah, actually, I don't know, but let's get it so that you get sole custody. So watch out for these type of attorneys or for your own behavior, because unless it's truly a domestic violence situation, long-term it can backfire big time. I'll give you an example. About 6 years ago, I had a client come to my office and she said she lost her custody completely. She was the bearing mother of a same-sex marriage. The children, twins, were at the party with her, and the wife had a fight with her wife, and she called a lawyer who advised her to file a restraining order. So she filed a restraining order, and the children were protected parties. She went and took the children, left. The other woman comes home, sees no children. She's afraid, she's calling, she doesn't know because she wasn't served with the restraining order. She calls the other woman, she doesn't pick up, and she files her own restraining order because she was disturbed in her peace, which is the definition of abuse, to find out the children were not home, although the other woman had a legitimate reason. So then there was a trial on the woman who took the children legitimately based on the restraining order, and the woman who filed the counter restraining order because her peace was disturbed because she arrived, has seen the children are gone. And the court said that the woman who filed second was more credible. She got the children. Then the woman who followed lawyer's advice to file a restraining order to take the children because they had a fight, and who knows, maybe the other woman said something insulting, that's considered emotional abuse. And that woman lost her custody completely. And the children were taken away. It was very dramatic. She was so upset. And when she came to my office, we started a recovery process, meaning she had to go through different programs. She had to go through rehabilitation, anger management, because the court found her not credible and actually the primary abuser. Because when you have a fight, it's kind of hard to say who is the primary. And after taking all the evidence, the court established that actually she was the primary abuser. Go figure. And so it took her a long time to get to joint legal custody. Very long time. So the moral of the story is to be very practical about filing a restraining order. Because on one hand, it protects you. On the other hand, it inhibits to communicate with the other parent. It creates a lot of situation that is, you got to think it through what exactly you want going forward, not based on the current emotional state. I'm not saying that the victim of domestic abuse shouldn't file a restraining order. Okay, I'm saying this is where it becomes a gray area. Another way to lose if the other parent using drugs, alcohol to the point where the children are watching it and it's not in their best interest to see that other parent taking the drugs and being not present. That is, of course, something the court will not allow, and the parent should not allow it and file immediately for sole legal physical custody. And then the parent who has the alcohol and drug issue will have to do a so-called sober link. So before each visit, they will have an iPhone. They will have to click something, breathe into it, and then the other parent will get notification. Okay, that parent is good to go, and the parent releases the children. Or random drug testing. Courts are not allowed to order follicle test. However, the courts are allowed to order urine test, random urine test, which means once a week, the parent who is presumed to be with the problem will get a call and has to go immediately within 2 hours and take the urine test. Unfortunately, it's not effective because the parent who takes the urine test will immediately drink because they know they're not going to get a call within the next 2 hours. So they take the urine test, they drink all day until they know they will get another call because it's once a week. It's not once a day next week. I would say sober link is more effective. We established domestic abuse, drug and alcohol, and erratic behavior, meaning that woman who filed a restraining order without being in the gray area, without legitimate reason, in court finding her not to be credible, that's another way to lose custody. So the bottom line is the court looks at what is in the best interest of the child. It's such a factual question. It's hard to establish. We also have relocation requests where one parent says, I would like to move to another country. And then the other parent might lose custody. We are in the area where it can go either way. In that case, the court could order custody evaluation. What is in the best interest of the child? If assuming one parent moves, should the child stay with the other parent, or what the visitation should be if the other parent moves, or let the other parent move and the child stay? So it's really difficult. I think I covered most of custody-related situations. If you still have any questions, ask them down in the comment section below, and I will see you in my next consultation. Bye!